When couples decide they're going to be proceeding with the divorce in Virginia, what generally are the options to do so? Attorney Shamika Harris explains, there are two paths for divorce in Virginia. If the divorce is amicable, a party may agree on drafting a contract, dispersing all assets, or determining custody of any children. It also may contain retirement details, determine how taxes will be filed, or assign debt. This contract is called a property settlement agreement. In Virginia, parties proceeding with a property settlement agreement must live separate and apart for 6 or 12 months before filing. For couples with children, 12 months of separate living arrangements are required, even with a property settlement agreement. For couples without children, it's 6 months. The property settlement agreement may also outline exact living arrangements for the 6 to 12-month time frame. Once the required time apart is fulfilled, a couple seeking separation may now file for an uncontested divorce. Upon the court's signing of the final decree, the divorce is completed. The second route for divorce occurs when parties cannot agree on the details of the separation. For this path of divorce, 12 months of separation are also required. If, after this period, no property settlement agreement has been outlined, a spouse may file a complaint. This initiates a contested divorce process. At any time during the contested divorce process, the parties may come to an agreement and sign a property settlement agreement. The spouse receiving the complaint will then have 21 days to submit an answer to the complaint and a counterclaim, which is their complaint for divorce. After the counterclaim, the first spouse then also has 21 days to provide an answer to the counterclaim. At this point, a pendente lite hearing would be set. A pendente lite hearing is a temporary hearing in which a judge will temporarily handle housing, custody, and financial concerns, as well as set the final hearing date. At the final hearing on the matter, the judge will hear evidence. The judge could provide a ruling on that date and require one of the attorneys to draft a final decree to be signed by both attorneys. Usually, the judge will take a few weeks to provide a written ruling to the parties and require one of the attorneys to draft a final decree in line with the court's rulings. Upon the court's signing of the final decree, the divorce is completed and finalized. Whether you need assistance with family law matters or are in a not-so-favorable position and in need of a criminal defense attorney, Shamika Harris is ready and waiting to serve those in Central Virginia. She has the necessary tools and experience to assist anyone seeking assistance with their family law or criminal justice dilemma.